Hello, my name is Hayden Miller. I'm from Sydney. I'm a barrister in Sydney. This morning it's my privilege to introduce the session number 8 on constitutional law and related matters. I've always thought that indirect tax without a few constitutional issues is sort of like a pie without sauce. Over the years we've had a few constitutional issues with the old sales tax. Excuse me. We had a number of them, and one that comes to mind is mutual pools and staff, one which is very close to Kevin O'Rourke's heart, I know. One that he lost. He won first and then through legislative change lost. But at least you had a win. And in GST we've had a couple. We've had Halliday and the Commonwealth of Australia, where there were 6 grounds for saying that GST was invalid. One of them that I really liked was that making Muslims collect tax is a prohibition on the free exercise of religion for the purposes of section 116. Needless to say, Justice Sundberg in the Federal Court had no problem dispatching those issues. And then O'Meara in 2003, where there's a challenge under section 55 of the Constitution on whether any of the GST acts dealt with more than one topic of taxation, which is prohibited under that section. This morning we are privileged to have one of Australia's leading constitutional lawyers. He is Peter Hanks, Queen's Counsel. Peter is a member of the Victorian Bar Association. He was formerly a university law teacher and a solicitor. He now practices predominantly in public law, administrative law and constitutional law. He was called to the bar in 1991, was appointed Queen's Counsel in 1999, and he's appeared regularly in constitutional and administrative law litigation for Commonwealth and state government agencies and against those agencies in the Supreme Court, the Federal Court, the High Court and various tribunals. He's also an author, a well-known author. He's the author of Constitutional Law in Australia. The second edition is now in print, but he tells me that the third edition should be out next year. He has been the author of Australian Constitutional Law for the first 7 editions. He's now handed over the reins to someone else, but his name, he's become something of an icon in constitutional law, so his name remains on the publication. This morning Peter is going to, the title of Peter's paper this morning is The State's Liability, a Constitutional Perspective. Would you all join with me in welcoming Peter, please?
Thanks, Hayden, and thank you all. This is a relatively focused or concentrated paper that I'm going to give. I only want to look at one particular question that has a constitutional dimension to it, although the solution that's currently in place, although it owes something to the constitutional issues, is not itself a constitutional solution. But my particular focus today is the payment of something that looks like GST, looks like, quacks like, forks like, but isn't GST, by state governments and state entities, agencies, of amounts that are equivalent to GST on the, to simplify the matter, the sales of state-owned land. Now, putting aside the fact that the owner of the land is a state, let's say, or a state entity. In Victoria it could be the Urban Land Authority, for example. In Western Australia it could be the Housing Authority of Western Australia. Putting that on one side, the sale of land would be a taxable supply under the GST legislation. The GST legislation, however, expressly exempts from the liability to pay GST a state, as it's put, a state where what is involved is property of any kind belonging to the state. And I've referred to that in paragraph 4 of the paper